Hi class, so I'm going to be doing my presentation on competence to consent to a search and seizure. My name is Amara Faison and just join me. So first I want to talk about what a search and seizure is. A search and seizure is when a person in law enforcement looks through an individual's house, their car, their persons to find evidence for or of a crime. The government gets most of their evidence for cases from searches and seizures. I want to talk a little bit about the Fourth Amendment and what it is. It prohibits unreasonable search and seizures and needs a search warrant along with a probable cause for it to be considered reasonable. An unreasonable search and seizure is when a person in law enforcement does not obtain a search warrant signed by a judge, does not have probable cause that the place or person has criminal evidence, or lastly, when they look in more places other than the ones that's specified on the search warrant. During a pretrial, if the court deems the search unlawful due to the actions taken or done to obtain the evidence, it will not be included in the prosecution's case, ultimately meaning that it will be inadmissible in court because it was obtained illegally, basically, or unlawfully. To understand if an individual was competent when they consented to a search and seizure, it requires a clinical evaluation. According to the U.S. Supreme Court, a valid competent consent to a search or seizure is one way the police action can be rendered reasonable. Ultimately, a search can be found reasonable even if the police do not have cause to conduct a search, but the person does agree to the search on their own. If a police officer detains an individual, it is also not a violation of the Fourth Amendment if that person agrees or is willing or willingly consented to the detention. Also, the amendment purposes a person's consent can be voluntary even if the person does not know that they have the right to refuse to consent. Also, an evaluation of an individual's competence to consent to a search is contingent on how much, if any, did the police coerce this individual. Whether or not the person knew or understood that they had the right to refuse to search is a completely different problem. Now we're going to talk a little bit about voluntary search involving coercion data. This is a simulated search that they did in our textbook. And if basically it stated that if a search request is phrased in a way that a person seems that it seems to be asked as a question, it results in people feeling as though they have a choice, i.e., would you mind if I came and looked around? If a search request is phrased in a demanding way or a declarative way, people felt that they had less of a choice, i.e., I would appreciate it if I could come in and look around. The data collected from the search lets us know that people subjected to a police request for consent may be more likely to assert their rights if the request is framed declaratively rather than interrogatively. Ultimately, meaning when a person was asked by the police if they can enter to search their home, people were more inclined to say yes and did not question the search, opposed to when they formed it in a statement. They also found that if police gave more information on why they were there or why they were doing the search, the consenter felt less inclined to ask them to leave once the search began. Now we're going to talk about fear in consenting to search, a study done by Lichtenberg. This study done by Lichtenberg seemed to be very different from the first study that was conducted. When people had search encounters with police, many consented to search out of fear. This study was done through interviews with 54 people who were deemed as consenters and police reports. All of these things that I am about to list were not factors in the decision to give consent. Consent was not based on how many people were there during the search request, the amount of demands the police officers forced the subject to go along with before consenting, if the subject was in a rush, whether or not the subject felt that they had to respond immediately, the number of questions the subject was asked, and the subject's education or employment status was not a factor. The biggest reason for giving consent was fear of reprisal if they were to refuse the search. Many of the subjects did not know they had the right to refuse the search, and the ones that did felt that they did, if they did refuse, their rights would be violated. Also, this study is interesting because the consent searches were conducted in Ohio, where in this particular area required the police to tell people in searches that they were able to leave before they requested consent to search in the first place. Now I want to talk about a search and seizure study data done by Nadler, I'm not sure how to pronounce the name. They found similar results to Lichtenberg. And in this study, the consent search cases, citizens did not feel comfortable declining a search request, nor did they feel comfortable ending the encounter once it had started. Many developed the idea that if they refused or terminated the search, that police officers would see it as they were being uncooperative, and because of it, the encounter would potentially end badly, or the citizen would endure negative consequences. Citizens only felt that they had two options, and it was either agree to a search that they really didn't want to agree to, or refuse a search and face some form of negative consequences if they refused. A lot of them did not know what the consequences would be, but they were still afraid to decline the search. This study data would be very helpful to the court systems and the people that work in it, such as lawyers and social scientists, to understand how willing people truly are to consent to a search based on their interactions with the officer that is conducting the search. In some ways, the willingness to agree to a search is contingent on how the police officer acts and the citizen's feelings towards the behavior or the interaction. Next, I want to talk about a few court cases on search and seizure. The first one is Mapp versus Ohio. This court case was a home search that now makes it so that evidence that is seized unlawfully without a search warrant is inadmissible in state court. Basically, a woman, the police searched a woman's home and found unlawful or inappropriate pictures, and they used it in court against her, or they attempted to, but because the evidence was obtained unlawfully, it was not admissible in court. Terry versus Ohio is our next case, where this court case was a search of a person. This case was one that deemed the stopping and searching of a person, or stop and frisk as we know it today, to be constitutional if the police had reason to believe that the person was carrying a weapon or was involved in a crime. So Terry versus Ohio was a situation where Terry and his friend were basically going to rob a bank. Their actions and behaviors let this police officer know that something was wrong, something was up, they were up to something. And the police officer ended up stopping them, and he frisked them or searched them. And in that, he found two guns, and Terry was charged and convicted of attempted robbery and having a weapon on his persons. The last case that I want to talk about is Brennan versus California. This court case was a traffic stop and a car search. The car search was, or the stop was for a suspected expired tags. And Brennan was not the driver of the vehicle, but he was a passenger in it. And this court case lets us know that everyone in a vehicle during a stop and search is technically being detained. In this case, the officer found that Brennan was a passenger in the car and he had a warrant, and there was drugs or methamphetamine drug paraphernalia in the vehicle. He claimed that the stop was unlawful because of the tags on the car indicated that there was a renewal in process, but the court did agree that the stop was unlawful, but the drugs that were found during the search were not dismissed or ignored to the court. So he was still convicted of basically violating his probation and the fact that he had a warrant. This case, although it wasn't for the person's car that was originally being searched, they found that people, or ultimately that things in a vehicle can be searched, although it was technically unlawful in this case. It's really just to let people know that everyone in the car, regardless of the search, is being detained ultimately. And the last slide is my references. Here are all my references, and I hope you enjoyed my presentation.